Hi, my name is Tim Sechler. I'm an estate planning attorney with offices in Mars, Pennsylvania, and I'm doing this video um, to provide some education on basic estate planning documents. And so this is not supposed to be an end-all be-all of estate planning. There are certainly some complicated things I'm not going to be covering in today's training. But what I find is, particularly for like young families, there's this kind of recurring and very common estate plan that we do for folks, and that consists of a will for what happens if I pass away. And the will is coupled with documents for incapacity. We need to do a financial power of attorney. We need to do an advanced medical directive for healthcare decision making. And I'm doing this talk for a couple of reasons. The first is I want people to make good decisions. There's too much stuff on the internet and people are being kind of swayed the wrong way. And this is my take on how this stuff really works in Pennsylvania. And I'm really also doing this because in my experience, families are busy. You know, I've got little kids, you may have little kids, and it's tough to go through a 3 or 4 meeting process with a lawyer to get these estate planning documents. But you also can't make those decisions within just 15 minutes. And so I'm providing this so that you have some time to think about it. So you've got some education. You can think about what your options are. You can think about what those choices are. And then toward the end of the talk, I'm going to talk to you about what the process is. And we've come up with a way to make this really easy to get documents done pretty quick without taking a whole bunch of your time. And let me get some slides rocking and rolling here for you. So the talk is about the estate planning basics. Again, my concern in doing this is somebody might watch this video and decide that a will and a power of attorney is the only thing they ever really need. And that's not really true. So if like you're approaching retirement age, if you are retired, if you're a senior and you got your hands on this video, understand that there may be some more technical, there may be some more advanced estate planning topics you need to consider. I have some other videos on that. I'm happy to share them with you if you reach out to my team. But this will still be a good use of your time. I'd still recommend watching this. And just for your sake, before we get into the slides, let's just chat for a second about what we're going to do here. My idea in doing this is that a family or an individual, or if you're married, you could take about a half hour, 45 minutes, wherever this thing ends up, out of your time to make some real decisions to get some process going to forward yourself in getting this estate plan done that you've been putting off forever. So here's what I'm going to challenge you to do. We're going to take the time. We're going to skip a night of watching Netflix or whatever it is you do with your time. Go pop the popcorn if you want to. But what I do want you to go do is grab a pen and a piece of paper. Pause the video. Go grab a pen, go grab a piece of paper, because I'm going to ask you to write some things down, and we're actually going to make some decisions during this video on how your estate plan is going to look, or at least then you'll know the blanks that you still need to fill and still need to talk about. So go ahead, pause the video right now. I'll wait, and go get yourself a pen and a piece of paper if you don't already have one. If you do have one, great. All right, let's get started. Back to our slides. Okay, so estate planning basics. Now, just a little bit about myself. I own the law firm here in Mars. I am a veteran. I served in Afghanistan back in 2005 and 6. We have a couple of offices now. I spend most of my time in Mars, but we see clients in Butler, we see clients in Newcastle, and then in the South Hills in our Mount Lebanon office. And I'm what's called a certified elder law attorney. So this credential is something that is pretty uncommon. And what it tells you is I do a lot of estate planning and nursing home crisis planning work for seniors. So if somebody goes into the nursing home and they're paying out, say, 10 grand a month on that care, we help them sort out those issues. So if you happen to know somebody in your family going through that, my office handles quite a few of those cases. Here's our agenda. So control and access, estate planning. These documents, wills, powers of attorney, healthcare directives, all we're ever really managing is who's in control of me and my things and who's got access to me and my things. And when I'm alive and well, if I get sick, when I pass away, who's in control, who's got access. We're going to talk about a couple of the basic documents you need. And then today we're going to make some decisions. You're actually going to get like maybe 60, 70% of your estate plan done today. We're going to save you an extra step, an extra meeting of coming to the office. And I think that that's really good for you. I hope that encourages some people to actually complete this work. So sound good? All right. So control and access. Who's in control? Who's got access to my stuff? This is the name of the game when it comes to estate planning. Here's the 3 time periods that matter. When I'm alive and well, if I get sick, and when I pass away. So today I'm alive and well. Who's in control of my stuff? Well, I am, my spouse probably, but I'm in control of my stuff. But we tend to take this for granted, because if I am on my way home this evening and I'm in a car accident, and tomorrow I wake up and I'm incapacitated, well, this gets a little bit more complicated. So we need to do some estate planning here. We need to plan for what happens if I bounce my head off of the dashboard. Tomorrow I'm confused and I can't make decisions. Who's making those decisions? Who's making my financial decisions? And who's making my healthcare decisions? We're going to go through that in a little bit more detail. And then when I pass away, then what happens with my stuff? You know, I've got some money, I got a home, I've got a retirement account. What happens with that stuff if I pass away? So these are the 3 time periods we're managing, control, and access. So first, incapacity decision making. There's 2 areas where this kind of we need to make some decisions. First is financial decision making. So, and then the second is healthcare decision making. So with financial decision making, either of these really, if you don't do any planning, see, the state of Pennsylvania and every other state, depending on where you live, has a plan for you. It's called guardianship, right? So if you end up becoming incapacitated, you can't make decisions, the doctor thinks that way, then what happens is your family members or your spouse is going to end up taking you to the courthouse to have you declared legally incapacitated. And then now the judge gets kind of in control of your stuff and starts making the decision, or appoints the person who's going to be your guardian. And then that person's job is to make the decisions on your behalf. But like, you may end up in a situation where the judge appoints someone that you don't want, or you may get in a situation where you haven't clearly communicated what it is that you want. Or, you know, it just may be that this is kind of a pain in the neck process, and now my guardian has to report back to the judge from time to time with what they're doing with my stuff, and I just want to avoid that process altogether. So in my opinion, guardianship is a process to be avoided. It is sort of like the incapacity last resort question. And so instead, what we want to do is we want to do a document. We want to do both a financial power of attorney, and we want to do a healthcare decision making. So this slide is sort of my thoughts on financial decision making. So we need to do a document called a financial power of attorney. Most of these are done in a format called a durable power of attorney. And the word durable really just means if you become incapacitated, the document remains in effect. And, you know, that kind of seems self-explanatory. Why would you do a document that stopped if you became incapacitated? But there was a time period when doing that was popular, where, you know, you had to be determined to be incapacitated before the thing worked. The logistics of that just didn't work out, because it tends to occur that people don't think they're incapacitated. And so then you got this sort of battle over it, and you end up with guardianship anyhow. So we need to do a durable power of attorney. This is a document that is effective immediately. It's effective when you sign it. You name the person. That person is called your agent, who makes the decisions, and it remains in effect until you pass away or revoke it. Now, one thing in particular, so the general idea here is we are naming someone to make our legal and our financial decisions for us. We name a primary, we name a backup, a contingent. One thing that tends to vary a lot in the way these documents are drafting, I just want to spend a little bit of time here, is the gifting powers. So the default rule in Pennsylvania is when you name somebody to be your financial agent, your power of attorney, what are they allowed to do? Are they allowed to move your stuff around? And I'll give you an example. Like if I became incapacitated, if I had a stroke, or if I got really sick and I was laid up in a nursing home or whatever, it may make some sense for my agent to move assets out of my name and put them into my spouse's name, or potentially in my kids' names once they're older. But that's gifting, right? And the power of attorney, this gifting is one of these sort of hot powers that we have to expressly plan for in Pennsylvania. We have to indicate our desires. And so there's limited gifting and unlimited gifting. Limited gifting means $15,000 a year to my close family members, which may be fine in a lot of situations. The other option is unlimited gifting, which means my agent can give away all of my stuff to the people that are already included in my estate plan, like my spouse, my kids, whatever. Unlimited gifting is particularly popular with older couples who are concerned about what happens if I end up in the nursing home. So if I'm working with somebody that's in retirement age, 60s, 70s, 80s, whatever it is, and they are concerned about what happens if I end up in the nursing home, what's going to happen with my stuff. We're typically going to recommend an unlimited gifting power so that if you do end up with a nursing home, we have some legal authority to shift the assets around. But that's one thing you're going to have to make a decision on: is limited gifting right for you, or is unlimited gifting right for you? And then who do you choose to be this decision maker? So the primary, if you are married, is typically going to be your spouse. I mean, that's just what most people do. I'm going to name my spouse as the first. If you're not, then you need to choose one of these other folks. Now, but we need to name a backup, because I don't know that the accident that results in your incapacity doesn't result in your spouse passing away. And, you know, my job is to sort of wrestle with and deal with and plan for terrible situations, and unfortunately terrible situations pop up from time to time. So we need to name a backup. If you're an adult and you have an adult children, then we probably maybe want to name those adult children to be your power of attorney, your contingent. If your kids are little like mine, you're probably not going to do that. I would name perhaps one of my siblings, or maybe my father, to be my backup decision maker. You may have a close friend who you trust to make these decisions. If you look around sort of your Rolodex and you don't have anybody that is in that close proximity that you want to trust, you want to burden with this issue, you may reach out to a professional, and we could introduce you to people that do that. A couple of things to consider: what's their background? I mean, do they have the financial acumen to make decisions? Are they on par with you financially, or do they have the maturity to handle that? Second is, what's their availability? You know, it can be awful handy to have someone close. It's not a necessity. I've got a lot of clients whose kids are out of town, and they still name their kids. But it can be helpful if we need to go to the bank or deal with local financial services to have somebody local. You know, I've got this little joke with clients: if you're trying to decide between the smart kid and the local kid, go with the smart kid, because a lot can be handled over the internet or on the phone anymore. Now, a common question I get is, can I name two people? Can I name both my kids? And my opinion on it is, you really should choose one. The answer is yes, you can. But I typically try to talk people into just doing one, because what happens if they disagree? You know, if you've got both your kids and one kid thinks we should do this and the other kid thinks we should do this, then there's no tiebreaker. And when you really boil it down, why people want to name joint agents under their power of attorneys, they really don't want to offend one of the kids. But then what happens if the kids are disagreeing? They're fighting all the time anyhow, and that relationship breaks down. So just blame me. You know, if it ever comes up, just say my attorney said that I had to only do one, and so I chose the oldest, the smartest, the closest, you know, whatever the case is. Now, that kind of makes me think about just one sort of caveat with this entire video that we're doing is, you really shouldn't do this stuff on your own. You know, I'm presenting this information, but I would encourage you to work with us or work with another law firm to get your estate planning done. Don't just print some document off the internet. One, you're probably not going to do it right. Two, their document may not be effective in Pennsylvania. You might not execute it right. Three, you're going to make some decisions that you don't really fully understand, that you really haven't thought through. There's a real problem with just getting a document off the internet. A document off the internet is not an estate plan. It's just a document. Plans have more to them than that. We got to think about the repercussions for taxes. We got to think about the repercussions for your non-probate assets, meaning like your IRAs and your life insurance. That stuff's not governed by a will, and so you can't just print off a will off the internet and think you're good to go. So, all right, now back to the information. So here's what I want you to do. On your sheet of paper, I want you to take a time. You got to pause the video. Great. I want you to write down who is going to be your financial decision maker. Primary is probably your spouse if you have one. If not, you know, one of these other people that you're close with. And then I also want you to write down the name of your contingent. And one more note I want you to do is write down, what do you think about gifting? Should we do limited gifting or should we do unlimited gifting? Now, if there's anything that you're unsure of in this workshop as we're going through the talk here, just write, need more information. Got a question for the lawyer. Just write that in the margin, and then that'll prompt us when we are having a conversation later that we need to take a deeper dive on something. All right, great. Okay, healthcare decision-making is what's next. Now, this is a document that we do separate from the financial power of attorney. It is commonly done in my office as a two-part document called an advance directive. Okay, the two parts are, we name our healthcare agent, and then there's a living will part that tells them what to do if I get really, really sick. Okay, so that's called an advance directive. I do it in a separate document because I have enough clients that want to name like their accountant daughter as their financial decision maker and their son that is a nurse to be their healthcare decision maker. So we separate it out. So we need to name the people that are going to make healthcare decisions for us and that are going to do it in a way that is consistent with what you want. So again, who do you choose? Probably your spouse first if you're married. Then you kind of go to that list of, okay, my adult kids, if I have them, my parents, my siblings, friends, whoever is close to you. But you want to choose a primary and you want to choose a contingent. And I would say that you should also be thinking about, what's their background. If you have somebody that has sort of been through this before, or if you have somebody in the medical field, that can be helpful. And really, are they going to follow through with your desires? I mean, we're talking about healthcare decision making. Often we're talking about the end of life, and you need to talk to somebody and you need to appoint somebody that is actually going to follow through on your desires. They're not going to hesitate. They're not going to lose their mind over this decision. We just want somebody that's going to read the document and say, okay, this is what Tim wanted. My job is to implement what Tim wanted, and they kind of have to have the backbone to make that happen. Okay, so go ahead on your sheet right now and say my healthcare agent is blank, and just list whoever that is. My backup is blank, and write down their name. You need to pause it, go ahead. You need to chat about it, fine. But my healthcare agent is blank, and then my contingent is blank. Okay. Now, let's talk about the second part of the document. So we're going to name somebody to be our healthcare agent. The next part is this. Two things. The living will part of this, all right? So living will is your expression of how you want to be treated in two situations. The first is an end stage medical condition, okay, end of life. So this is a situation that is going to result in your death despite medical treatment, okay? So if I'm really, really sick with advanced cancer, they could give me the chemotherapy, but I'm going to pass away anyhow, right? So it's an end stage medical condition. A condition which is going to result in your death despite the introduction or continuation of medical treatment, right? The second condition that's going to apply is an irreversible coma or irreversible vegetative state. So the way the document reads is, if I have an irreversible coma or irreversible vegetative state that has no realistic hope of recovery, okay? So essentially multiple doctors all feel that I'm not coming back from this, okay? Then, in those two situations, end of life, irreversible coma, how are we supposed to treat you? Okay, would you want life-sustaining treatment? Do you want them to take all measures to keep you alive as long as possible? Or are you going to take the approach that says, no, if I'm in those situations, let's not drag this thing on. I want life-sustaining treatment without a withdrawal. And that could mean a lot of things. It could be CPR, it could be a mechanical ventilator, it could be chemotherapy, radiation, surgery. Some of those healthcare treatments that we typically think of, you do this to get somebody better, right? And we're in a situation where that stuff's not going to get you better. It may prolong it a little bit, but you're going to pass away from this anyhow, or you're going to be in the irreversible coma anyhow. Now, a couple of more nuanced things, a couple of more detailed things is when we sit down, you're going to go through the document with one of our folks, and you're going to initial here and initial there. Now, one of the things I'm going to ask you about, if you were in an end-stage medical condition or a coma, would you want food medically supplied by a tube in any part of your body? Okay, so that's something you want to wrestle with before you come to the office, because it doesn't go well if I just slide this document in front of you and you haven't thought about it before. So if you are in an end-stage medical condition or an irreversible coma, would you want food and water medically supplied by a tube? For the ladies out there, if you are pregnant or could become pregnant, there's a question on there about whether we treat the baby's life as whether we would withhold medical treatment if it increased the viability of the baby, or the reverse, keep me alive as long as possible, even if it affects the baby negatively. So you got to wrestle with that. And then at the very end of this document, there is an option for shall or may, right? So my agent shall follow these instructions. These are my instructions. My agent is just there essentially to communicate my desires to the doctors. Or my agent may follow these instructions, but my agent may also override these instructions if, based on what he's seeing, he or she is seeing, what's actually going on, they feel like there's another decision to be made. So that's something you might want to make a note on your form that you're working on there, is my agent shall or my agent may. Okay. So now we've worked through the financial power of attorney. We've named the people. We made a decision or two on how the thing reads. Living will. You've named the people. You're at least giving some thought toward how do we want to fill out the form when you're in the office. Okay, now moving on to the next period is who's in control, who's in access, who's got access after I pass away. A couple of things I think you need to know first. Now, this question here, do I need a will or a trust, is probably my most common question when people come in. We see about people doing trust. I've got friends that have done trust. Should we use a trust? I'm gonna take a glancing shot at trust toward the end of this thing. Most of what we're going to talk about today is will-based planning. Here's what I think you need to know first. How do you own your stuff? There's different types of legal ownership. What is a will? What is probate? And then what is a trust? And why do people use them? So these are different types of legal ownership. My wife and I, we have both our names on the checking account. If I pass away, she gets the checking account because she is the joint owner, right? Joint with survivorship. So we're both on the house. People put their kids on as owners on accounts. When you do that, when you pass away, those assets just go to the joint owner in most situations. It doesn't matter what the will says, okay? And then the next way that we own assets is beneficiary designated. A lot of us own assets this way. So you've got a good example is life insurance or an annuity or an IRA. So the asset is mine during my life, but when I pass away, I've told the financial institution where to send the money. So life insurance is real easy. I've got this life insurance contract. If I pass away, I name my spouse or my kids as the beneficiary. The life insurance company does not care what my will says. So a lot of assets are beneficiary designated, which is good and bad. It's good because it's simple. It's bad because you're only allowed to answer one question there, right? You only really answer the question, who gets the stuff when I pass away? But beneficiary designations don't allow you to do some of the more complex stuff like, well, what happens if my spouse passes away at the same time I do? Now it's going to my kids, but my kids are little. Who's in control of that money? Until what age? What terms are they supposed to manage that money? And so if you want to answer those questions, we got to take a little bit more proactive approach with our estate planning. The third way that we own our assets are individually owned assets. So it's like a checking account in my own name, a car in my own name, real estate in my own name. When I pass away, these assets go through the will, right? And if you've been around, like when somebody passes away, this is why when the first spouse passes away, there really is no estate to administer because husband and wife tend to own everything jointly or beneficiary designated to each other. So when the first spouse passes away, it just goes to the other person. But then when the second spouse passes away, when she passes away, now she owns the car in her own name and she owns the house in her own name, and that stuff's going to end up going through her will. So let's talk about the will. What is it? It's a document that names who gets your stuff, right? It only governs those assets in your own name unless we take action to like send other assets through the will. It names your executor. Now that's the person who is in control. Now, typically, the executor is the same person you name as your financial power of attorney because the person is managing the finances right up until you pass away with the power of attorney document. When you pass away, that document's over. Now we're shifting to the executor of the will, but we typically would name the same person for both roles. This will allow you to name a guardian for your minor. So what does that mean? Well, the guardian is the person who, like in theory, steps into the shoes of the parents. So if I pass away and my wife passes away and now we've got these little kids, they're minors, we can appoint, say, like my sister or my brother to be their guardian. So now if they accept the responsibility, my kids go live with them. Now they step into the shoes. They make healthcare decisions for my kids, education decisions, religion decisions. They step in and make the day-to-day decisions on how it goes. So if you have little kids, this is somebody that you want to think about. You might want to pause the video right now, chat with your spouse if you're sitting there next to each other. Who would be the person we want to name as the guardian of our kids if we both passed away? And go ahead and write that down. And if you got any questions about that, again, in the margins, just say, I got an attorney question. Okay. Now, there's some other important questions that we need to answer in this will, not just who gets it, okay? So a couple of common ones is, what happens if my kids are young? Where's the stuff go? Like we just talked about naming the guardian, but that might not be the answer solely for what happens with the money. Or what happens if I have a disabled kid? Disabled people tend to ask the government for help, needs-based benefits like Medicaid. We can't just leave them money because then they have too much money to have their free health care. So we've got to wrestle with some other important questions. We're going to ask you about that when we have our conversation. And then a lot of wills will set up like a testamentary trust. All right, so I'm going to give you an example here. So let's say I pass away and my wife passes away, and we've got these little kids. Now, I've named a guardian. I've named the person who's going to look after the kids. But I might want to put a little check and a balance in here. So let's say, for example, that I name my sister as the kids' guardians. We may decide to name my brother or my wife's brother to be the trustee on the money. Okay, so the will kind of creates this little legal entity, this little pot called a trust, a testamentary trust, last will and testament. So this is a trust that does not exist until you pass away, but when you pass away, assets end up in the trust. Now, the person in control of the trust is called the trustee, and the people who have access to the trust are called beneficiaries. So in the example I'm kind of chatting with you about is, okay, I've named my sister as the guardian for the kids, but we're going to funnel a bunch of the money to a trust managed by someone else. So now when my sister needs a bunch of money for the kids, she's got to ask someone else. And now they're both looking at the situation, kind of making decisions on how the thing goes. And then you got a little bit of check and balance. Now, sometimes families will name the same person to be the guardian and the trustee. And the reason for doing that is we can run a testamentary trust to like age 25 or 30, whereas in a lot of situations, if you don't use a trust, then the guardians may lose control over the money at age 18 or 21, which would be, in a lot of people's opinions, too young for those kids to get control of the money. So, all right, so here on the will, we on your sheet, we should already be writing down the names of an executor, the name of the guardian, and if you want to do an underage trust or some other reason we need to do a testamentary trust, write down whether you want it to be the same person as the guardian or if we want to name someone else entirely. Okay, so go ahead and just kind of jot down your thoughts there. That's probably a question we're going to need to chat about a little bit on our phone call. Now, wills, so if you haven't, go ahead and pause the video if you need to chat about that. I'm going to kind of move on to the next issue. Wills must go through this process called probate. So probate by definition, I had a slide on the testamentary trust. So common types are trusts for underage people, disability trusts. So do you need one is question one, and then who's going to be the trustee is sort of question two. Okay. So I started to say wills are going to go through probate. So probate by definition is the administration of an estate through the courthouse. So typically, if someone passes away, if they have a will, they've named the executor of the will, we got to put some stuff in the newspaper. The executor's got to go to the courthouse and get sworn in. And it could be a year later before we're making distributions. Control is ultimately with the judge. And this stuff can get expensive. It's common in Pennsylvania for lawyers to charge on a percentage basis. So somewhere between like say 2-4% of your net worth just to get the stuff to the kids. And then the kids are going to fight, because if the kids are going to fight, this is kind of where it happens, right? And we're already sort of in the boxing ring, right? We're already in the courthouse, and everybody's got their opinion on how this thing should go, and all the chips are out there on the table, and so sometimes people talk about avoiding probate. Now, I just want to make a point real clear. If you use beneficiary designations on your assets, those assets, when you pass away, are going to avoid probate, right? Which is good. It's handy. It goes quick. But the problem with using beneficiary designations on your assets are you don't get to answer any of those other questions. Like, we're not setting up the testamentary trust. We don't get to do any of sort of that more advanced planning. We can use a will as an alternative, and that allows us to do that more complex planning, the underage trust and all the rest, but wills have to go through probate, right? So sometimes people say, well, I want to do the more advanced planning, but I also want to avoid probate. And so then we typically will use a document called a revocable living trust. So the idea is, I use a little red wagon to describe the concept of the trust. And so let's say I had a home, or I had some money. I create a trust. Now, the only place the trust exists physically is paperwork, right? The lawyer draws it up, you sign it, you just gave birth to this new legal entity, and then you got to give it ownership of your stuff. So put it in my house, put it in my money. Now the trust, the little red wagon, owns the stuff. Now, the person in control, the person who has the handle to the little red wagon, is called the trustee. That's the person making the decisions. The people who can use the stuff, they can dip into the trust and take the stuff out, are called beneficiaries. Those are the people who have access. Okay, so not going to get into a lot of detail here. I've got other videos on using trust. I just want to make this mention to you, because if you are super concerned about avoiding probate and want to consider other options, revocable living trusts are very common estate planning documents. We do a ton of them. We put assets into the trust. It's a better vehicle maybe to manage your assets during your life. When you pass away, it avoids probate. So this is a document that, because the idea here is, excuse me, when you put your assets into the trust, you technically don't own them anymore. So when you pass away, the trust doesn't. It's just that the assets in the trust then go on. And the trust says the same thing that the will says, equal shares to the kids or whatever your testamentary desires are. But trusts are administered around the lawyer's conference table rather than in the courthouse. Tends to save some time and some expense and some headache. So revocable living trusts are used in place of a will. They kind of do the same thing the will does, but maybe a more efficient process on the back end. So that's a revocable trust. Now, we have also got something is going wrong. Hang on just a second. We also have asset protection trust. So for some of our clients, in particular clients who are concerned about protecting assets from the nursing home, we will use an irrevocable trust. And the general idea is you put your stuff in a trust, you can maintain certain controls, like you could be trustee, or you could change trustees, or you could change beneficiaries. So you can have a lot of flexibility, even though it's an irrevocable document. And by giving up access to the assets in that document that are owned by that trust, a couple of years later, 5 years later, those assets are no longer available if you end up in the nursing home. And so if you have that concern, or maybe you have family members that have that concern, this is pretty complicated stuff. I've got other trainings on that I'm happy to share with you. But asset protection trusts are pretty popular because everybody kind of knows if I end up in the nursing home, I'm going to go broke. And so is there a step I can take to protect some stuff? And that's an asset protection trust. Let me know if you want to take a deeper dive on that. I'll get you some good information. Okay. Okay, so let's talk about where we go from here. We talked about the basic estate planning documents. We went through and we named our financial power of attorney. We named our healthcare power of attorney. We named our executor. One thing that we didn't actually chat about when we went through the will is, go ahead and write this down now, who gets the stuff, right? I mean, if you're married, it's probably going to go to your spouse first and then to the kids. In fact, let me slide back before we get up to the process. There was a slide here. All right, so we talked about who's your executor. We talked about who's the guardian. Do we need a trustee for the kids? Who receives an inheritance? So the most common answer here is my spouse and then my kids. And then what happens if those people have passed away? If I don't have kids, then maybe other people like family, friends, nonprofits. And we have to always be thinking about, okay, I'm going to say everything to my kids, but what happens if my kids pass before me? Or I'm going to say everything to my brother, but what happens if my brother passes away before me? There's a couple of different options. Usually what we do, and we'll chat about this, is like if your kids pass away before you, then maybe if you have living grandchildren, it would go there. Or if you're going to leave everything to say like your brother, but your brother's passed away before you, maybe it goes then to your nieces and your nephews, or extended family, and maybe a nonprofit. We got to kind of chat through that. We'll give you some decision-making process to get through that. Sorry I skipped this earlier when we were chatting about the will, but that is certainly a decision we're going to have to make. So we went through this. Okay. Now, here is the regular sort of law firm process. We run this process on a lot of our clients. And what you do is people call, they end up in the office. We do this educational meeting, which has kind of been replaced here today by this video. Okay. So the idea is we go through options: wills, trusts, powers of attorney, control, access. We go through all of that stuff. And then we ask you about your goals and concerns. So my goal in doing this video is we have this education meeting, and then we do the design meeting with the lawyer. Now, the design meeting with the lawyer is you ask us more questions, we clarify your options, you make a decision on what type of documents you want to have, you make a decision on what those documents are supposed to say. Then we move on to yet a third meeting called the signing meeting, which is where we review your documents, you execute them, you sign them, and then now you have your will and you've got your power of attorney, you've got your trust, or whatever that process is. Then you end up with this sort of maintenance program, and also like a funding process that can go on and on and on. And so what I'm trying to do for folks, particularly with my will-based plans, is really simplify the process and save you some time, because I know it's hard to get off work to come see us. And so here's what I think we can do after watching this video is we're going to just skip straight to the design meeting. And the idea here is you have sitting in front of you, if you've been doing kind of what I asked you to do, you've got sitting in front of you a lot of the answers that we need to be able to draft good documents. We don't have all the answers. There's some things that we still need to chat about, but we got a lot of them. And so what we can do is what I'm going to ask you to do after the video is take the notes that are in front of you, type them up, and email them to me at info@sechlerlawfirm.com. info@sechlerlawfirm.com. You send us that stuff. We're going to ask you a little bit about, your information. I'm going to reply back like, here's some things we need to know. But if you send me that information now with the people named in the document, I want their spelling correct, right? Because the way you send it to me is the way we're going to type it into the documents. And what we're going to do is we're going to schedule a meeting. Now, we could do it in person. We could do it over the phone. We could do it on Zoom. We could do it a lot of different ways. We could do it over your lunch break. But the idea is, all right, you're going to send us that thing. We've got a good idea where the estate plan is going, but there's some blanks we need to fill in. So we're going to get on the phone with you. What do you think about this? What do you think about that? What do you think about this? The result of that meeting is we're probably going to have enough information to write the documents. At the end of the meeting or during the meeting, I'm going to talk to you about pricing. Here's what I'm going to say about pricing today. I'm 100% flat fee. So I've got wills that cost this, trusts that cost this, but I really want to narrow in and focus on what it is that you want to accomplish before we get the price. And if you hear the price, you don't like the price, you don't have to hire us. But it's 100% flat fee, and you're going to understand the price before we ask you to make a decision. Assuming the decision is yes, we're going to move forward with some documents, then we do have to meet you for a signing meeting. Okay, this is required by the law. You can't do a will without the proper execution. You can't do a power of attorney without a notary. We got to do it correctly, which is one of the problems people make when they end up downloading their own documents off the internet. Is they got this document, it's not really well thought through, and then they don't even execute it correctly. So we're going to make sure that that gets done. So we've taken this down from, like, say, 3 or 4 meetings, and I think we can have a phone call. We can have one meeting. You come in, we'll go through your documents, we'll sign your documents. And then you're on your way, and you've got this thing you've been putting off done. You got this estate planning done, which I think is a really good idea. So hopefully that process is appealing to you. Drop me that email at info@Sechler Law Firm, or give us a call. Give us a call. My phone number is here on the slide, 724-841-1393. So drop me an email, info@SechlerLawFirm.com. Schedule a meeting. Give me a call, 724-841-1393. Feel free also to just go on the website and cruise it. There's some information on there. I got a whole bunch of blogs on there about different things you should be thinking about, so feel free to cruise the website. And here's kind of the question I have for you is, you're watching this video, you made it through the whole thing, and you and I both know you need to do some planning. But my question for you is why? Why do you need to plan, right? And, people tend to focus on the stuff. They tend to focus on the money. They tend to focus on the assets. They tend to focus on the house, but it's really about people, okay? You are doing this estate plan to make sure that your family's okay, that you've got proper decision-making in place so that if you get sick, the world doesn't turn into chaos, so that your spouse is okay, so that the kids are okay. We're going to do trust-based planning for your kids if that's what you want to do, to make sure that your kids have money until a certain age so they don't blow it on their 21st birthday. And then we got proper people with the correct morals and values managing these assets, raising these kids, and taking care of the situation. So you need to plan because you got some stuff, but we really need to plan because our family is just too important to not get this thing done correctly. You're out there, you're saving money, you're working hard, and don't make mistakes in the end game. If something terrible happens, don't leave your family exposed to mistakes and confusion. Okay, so hit us up for the consultation. I'd like to chat with you on the phone. One of our attorneys will get with you. We can probably figure about a half an hour on that phone call, and then we have enough information to take it and do the signing meeting there. Again, here's my website. Here's my phone number one more time. I appreciate your watching this video. Go ahead, take those notes. Do it today. Type this stuff up. Get it to us in an email. Or scan your notes and send it to us, whatever you want to do. And we're like 60, 70% of the way toward having your estate plan done right now. So I appreciate your attention. I look forward to chatting with you, and give me a call when you're ready to move forward. All right. Thanks a lot.